Hi everyone, my name is Ariana and welcome to my Canadian Criminal Law podcast. I'm a law student at Western and today we're exploring one of the more controversial and nuanced partial defenses in homicide law, provocation. This defense can reduce murder to manslaughter, but it's only available under very specific conditions. Today we'll talk about how provocation works under sections 232 of the Criminal Code, how courts interpret it, and why it's been both narrowed and criticized in recent years. Let's start with the basics. Sections 232 of the Criminal Code says that a person who commits a culpable homicide that would otherwise be murder can have their charge reduced to manslaughter if they are acting in the heat of passion caused by sudden provocation. This means that provocation is not a full defense. It doesn't acquit the accused, but rather a partial defense that reduces the severity of the offense. The idea comes from the notion of human frailty, that people can lose control when provoked in sudden, extreme ways. As stated in the case Hill, the law recognizes that we're not all perfect, rational beings all of the time. But it's important to understand that provocation doesn't negate the intent to kill. In fact, it assumes the accused had intent. It simply reduces moral blameworthiness due to the emotional state caused by provocation. For a provocation offense to succeed, the court looks for four key elements. First, the court looks to the criminal conduct by the victim. The victim's actions must amount to an indictable offense punishable by 5 or more years. This is a relatively new requirement that replaced the older and broader standard of wrongful act or insult. Second is the objective loss of self-control. The conduct must be sufficient to deprive an ordinary person of self-control. Third is the subjective loss of self-control. The accused must have actually lost control. And fourth, the suddenness. Both the act of provocation and the accused's response must be sudden. There must not have been time for the passion to cool. All these elements are questions of fact, and the judge must find there's an air of reality to the defense before allowing a jury to consider it. The most debated part of the provocation test is probably the ordinary person standard. Historically, courts didn't allow personal traits like age, gender, or culture to affect the standard. But over time, especially through cases like Thibert and Tran, that changed. Now, the ordinary person is expected to be on the same age and sex as the accused, have experienced the same series of acts or insults, be situated in the same context, but not to share personal biases of extreme emotional tendencies. As the Supreme Court said in Tran, the ordinary person standard must reflect contemporary societal values, including equality under the Charter. So while a person's race or background may inform how a comment is experienced, like a racial slur, courts will not accept arguments based on homophobia, misogyny, or honor-based violence. The goal is to keep the standard fair, but not excuse violent loss of control just because someone has a short temper or personal prejudice. Suddenness is key. The idea is that provocation can only reduce murder if the reaction was immediate, before the person had time to, quote-unquote, cool off. If someone stews in anger and kills later, the defense doesn't apply. This was confirmed in Tripodi, where the court said that the provocation act must hit the mind unprepared, create an unexpected emotional shock. So, for example, finding out your partner had an affair 6 months ago might make you angry, but it wouldn't count as a sudden provocation under Section 232. Importantly, the accused's own condition, including intoxication, may affect how quickly they cool down. Courts look at this subjectively, but within limits. Provocation has sparked a lot of debate. Critics argue that it has sometimes legitimized male violence, especially against women and LGBTQ+ people. For example, historically men have tried to use provocation when reacting violently to sexual advances from gay men. Today's courts firmly reject that rationale, as seen in Tran. There's also the question, why should this only apply to anger? What about people who commit mercy killings out of compassion, like a parent ending a child's suffering? The law hasn't extended provocation that far. That said, narrowing the defense to only cover criminal acts by the victim has addressed some of these concerns and reflects a broader effort to align criminal law with modern social values. To summarize, provocation is a narrow and carefully scrutinized partial defense. It recognizes that people can lose control, but only under extreme, sudden, and specific conditions. The accused must show that a serious criminal act by the victim provoked them, that they and an ordinary person would have lost control, and that the killing happened on all of a sudden, not after time to reflect. Thanks for tuning in. I hope this helped clarify how the law of provocation works in Canada. Stay curious and stay critical. That's what criminal law is all about.